2025, I stated to this Honorable Court on record, on behalf of His Excellency Rigathi Gachagua, that he was abandoning his prayer for reinstatement as Deputy President of the Republic of Kenya. To that end, His Excellency Rigathi Gachagua amended and served his re-amended petition dated 13th of August 2025, in which further re-amended petition, he abandoned the prayer for reinstatement. I wish, again, my lords, your leadership, to reiterate that position on record. My lords, the prayers of the first petitioner are set out in prayers A to R in the said further amended petition, which, as I have said, is dated 13th of August 2025. The core of those prayers can be summarized as follows. One, the quashing, if this court agrees with our submissions, the quashing of the unconstitutional impeachment. Number two, payment of the remuneration he would have otherwise earned, plus, of course, all the benefits as per the law, plus damages. Finally, for the period of 2.5 years that His Excellency Rigathi Gachagua served as the second Deputy President of the Republic of Kenya, it is our submission that Article 151 of the Constitution is fully applicable, and I invite your lordships and your leadership to have a look at that Article 151 when you retire. Briefly, my lords, impeachment cannot and could not have been retrospective. That is the submission. My lords, your leadership, the petitioner, first petitioner, relies on the following documents. One, his further amended petition dated 13th of August 2025, the verifying affidavit thereto, and the annexures, which are in 9 volumes, dated 18th of October 2024. Number two, his bundle of authorities and case digest, dated 7th of October 2025. And number three, the first petitioner's written submissions, dated 7th October 2025, which submissions are the ones we are highlighting today before this honorable court. My lords, paragraph 1 to 19 my colleague is drawing my attention that we are also relying on the first petitioner's rejoinder to submissions, which you are served rather late in the day, but the rejoinder is dated 27th of April, 2026. Thank you. My lords, your leaderships, paragraph 1 to 19 of our written submissions sets out the critical background and gives context to the impeachment and the submissions we have made with regard to that impeachment. And I politely invite this honorable court, when it retires, to read this background in full. But permit me to briefly draw the court's attention to only 3 matters in that background. And the first one is to emphasize the total and absolute lack of meaningful public participation. And I would draw this honorable court's attention to paragraph 5, which you will find at page 7 of our written submissions. My Lord, page 7 of our written submission, paragraph 5, is what I'm briefly referring to. The National Assembly conducted a public participation exercise on the 4th and 5th October 2024. However, the exercise was not adequate or meaningful. The exercise did not provide the public, for example, with the Deputy President's side of the story. The public was only presented with the allegations made by the National Assembly. And our submission is that if there is going to be effective public participation, it was essential for the public to be presented with what the Deputy President was saying. But that was never done. In Nairobi, for example, in the county of Nairobi, the National Assembly public participation for the county of Nairobi, capital city. The public participation at the Bomas of Kenya was presided over by select ODM members of parliament from Nairobi County, who repeatedly asserted that the event was for invited guests only. My Lord, it is our submission that that is a mockery of effective public participation under the Constitution. And you'll find what I'm saying in the exhibit, my Lord, in exhibit marked RG 5 in volume 6, page 757 to 758. And also exhibit marked RG 7 in volume 6, page 764 to 765. My Lord, the second issue I would like to highlight is the rush from the word go, that the entire process was conducted by the National Assembly through to the Senate, breakneck speed. Like our submission, is that the only inference that can be drawn, and we drew, and we invite this honorable court to draw, is that there was a predetermined result that the National Assembly and the Senate were rushing to achieve. Technical perception that they were doing what the Constitution requires, when in fact nothing of the sort was happening. My Lord, if you look at paragraph 8, 9, and 10 and 11, and they appear from page 8 of our written submissions. Paragraph 8, my Lord, you see the respondent, the third respondent, convened a session of the Senate on 8th October 2024, which then passed a resolution that the plenary would hear and consider, and I pause here to emphasize the word plenary, my Lord, because both the Constitution and the standing orders of the Senate divide impeachment proceedings into stages: committee and plenary. And if the person to be impeached is to get any fairness, fair trial in the impeachment, the Senate cannot legally, constitutionally bypass the committee. It is the committee that accords an opportunity to the person to be impeached to be fully heard, not the plenary. And we will be highlighting our understanding, our interpretation of the law, that the rules of natural justice and on a correct interpretation of the relevant provisions of the Constitution, the standing orders, it was not open to the Senate to bypass the committee of the Senate, where the law gives the Deputy President, the first petitioner, the opportunity before a smaller committee to fully present his evidence, be represented, and be heard. And the 10 days that later the Senate imposed itself on refer to the committee of the Senate, not to the plenary. Lord, paragraph 9, hearing before the Senate commenced a schedule on 16th of October 2024, when the Honorable Mwengi Mutuse's evidence was fully discredited in cross-examination, and this Honorable Court will be taken through all that by my learned friends here. Number 10, paragraph 10, on 17th of October 2024, that was on the second day of the hearing, the Senate allocated the Deputy President 2 hours to present his case. You will see, and you will be addressed, my lords, the fact that somehow the National Assembly was allocated 3 hours. Yet, the person that was being impeached was the Deputy President, not the National Assembly. Lord, all these and many more is evidence of clear bias on the part of the National Assembly, despite on the part of the Senate, despite the Senate being presided, and I must state this, by a speaker who I personally have the highest regard for as a professional colleague. But on the second day, and I'm looking at paragraph 10, when the Deputy President was supposed to present his case in the 2 hours that he had been allocated, he fell ill and was rushed to hospital for urgent medical attention. Rejecting the request for adjournment, the Senate voted to impeach the Deputy President on 5 out of the 11 counts. And you find all that in RG 11, Volume 9, pages 1689 to 1725, response by Rigathi Gachagua. And also RG 12, Volume 9, pages 1752 to 1758, communication from the chair. My Lord, the third matter I wish to very quickly draw the court's attention to in this introduction background is the absolute failure for both the National Assembly and the Senate to address their minds to the threshold